Good evening, Captain Retired Matt Edwards here. Next installment of the Observation Post Facebook Live weekly update for the 17th of August 2023. You might hear my dog Clara barking in the background, but I'm gonna bash on. Okay, what I'll do is quickly go through 4 different items I have in my list of numbered items in my files group. Then I plan to talk about the Granovsky Supreme Court of Canada case and the Canada Pension Plan in general. So, without further ado, number 315 on the list. Provincial law says that no one can intercept insurance. Why? It should be self-evident. Insurance is designed for when something bad happens. So no one should intercept it because you buy it for a rainy day. If people could intercept insurance, it would increase the risk of the taxpayer having to pay, and therefore it will be bad public policy to allow creditors, and by that I really mean judgment creditors, because in order to access some money that you get, and if you owe money to someone, they're supposed to take you to court, prove it to a judge. After that happens, you have what's called a judgment debt, and then people can collect it from whatever means available. However, some things are off limits, like pensions, social assistance, insurance, things like that are not supposed to be touched. Number 316, qualifying retroactive lump sum payment is a lump sum. So why does Income Tax Act Section 61F allegedly apply? The basic principle is void. Now, what I'm getting at is something, even though I wasn't part of the Dennis Manouche class action from 2012, they had to pay taxes on the damages that the government paid to make them whole. Now, one of the principles for damages is that no taxes can apply to the payment that is supposed to make you whole after someone harms you. Now, in the case of the Dennis Manouche class action, you had people who were harmed by the Pension Act being used as a cat's paw for the government to save money on its long-term disability costs. It wasn't saving money under the Pension Act, but the Pension Act was used as the reason to lower the payment. So after they won, they should have gotten all of their money to make them whole. However, and some people might not like me criticizing McInnes Cooper, but I think McInnes Cooper fucked up. Because instead of looking at the payment and saying that this is legally damages, its legal characterization is damages, they allowed the government to call it income, and they said that Income Tax Act Section 61F has to apply. Now, there's an important provision in Income Tax Act Section 61F, and that is 2 conditions, actually. In order to be taxed, a long-term disability policy, first of all, must be a periodic payment. Now, periodic is the opposite of lump sum. So therefore, whether or not it was damages or whether or not it was income is a moot point, because the word says periodic, the payment wasn't periodic, so the government can't tax it legally. But they got away with it. Now, the qualifying retroactive lump sum payment rule was put into Income Tax Act Section 120.31, if I recall correctly. And they were supposed to allow people to get an extra break if you got a lump sum, say, of $600,000, like some veterans might have got from the CISA class action. Now, if it was income and they put it all in 1 year, it would get the highest amount of taxes because of the marginal tax rate being so high. So the government said, you know what we'll do to help people out? We're going to let you split up the money and put it in the years that the money should have been paid. So Corporal retired Tom Anderson, for example, had illegal clawbacks from 1996 to 2012, 16 years. So they allowed him to spread the money out over 16 years, so should have saved taxes because, assuming it was taxable, of course, it would have been spread out, and in each year the marginal tax rate would have been lower than had it been paid in 1 year. But some, I'm struggling not to say a really bad curse word, I'll say son of a bitch instead. They decided that the government shouldn't be out the interest, the time value of the taxes that should have been paid. So they put in to the qualifying retroactive lump sum payment formula a penalty. They call it a tax, but it's a penalty. That is Treasury bill plus 2% compound daily interest. So that's why people ended up owing a lot of taxes. That's not fair. You shouldn't mitigate people's damages by taxes in the first place. That's unethical, immoral, and illegal. But to twist the law from what was supposed to be a helpful thing into such a negative thing is truly awful. Tax-free Canada Pension Plan Disability, the will of the people, in a 2003 government study. Now, this is a strange one because, as far as I know, it might have been tax-free from 1966 to 1989. Or just as well as be tax-free because they didn't issue a T4AP tax information slip from the government for Canada Pension Plan Disability for the first 20-odd years of the program. Now, if you don't issue a tax slip and you're the government who does taxes, I think it's a pretty strong indication that there's not supposed to be any taxes. Now, in a 2003 report on the Canada Pension Plan Disability called Listening to Canadians, the Parliamentary Committee, HUMA, don't ask me what it means, I could look it up if I care, they recommended that the Canada Pension Plan Disability payments be tax-free. Now, the government makes laws. The government collects taxes. If a government committee recommends that it be tax-free, why isn't it tax-free? Well, the answer to that is that the government wants their money back. On average, according to a report I've read somewhere, can't tell you the source of it right now, but the government gets back 16% of all payments, such as old age security, Canada Pension Plan, and stuff like that. So I have to wonder, when they come out and say, we spent this much money on the old age security in a given year, do they factor taxes in? Because in accounting, you should take into account both the pluses and the minuses. If you give people money in the old age security, but you get it back in taxes, then you only paid out a net amount of old age security. Same thing for Canada Pension Plan. If they tax it, which, by the way, I'll throw this in there, even though I'm not bragging, but I think that they're applying the law wrong. They tax the Canada Pension Plan Disability under Section 56 of the Income Tax Act, and it doesn't read the way they want it to read, in my opinion. It sounds like if you get a pension in lieu of something else, but that's not what you're getting with the Canada Pension Plan Disability. You're not getting it in lieu of something. You're getting it because you bought a social insurance. Now, I can't go on too much about that because I'd have to refresh my memory. But when I've read cases about Canada Pension Plan Disability being taxed, I remember seeing Section 56 of the Income Tax Act mentioned as the charging section. Now, the thing about it is the Canada Pension Plan Disability is a long-term disability insurance, really. And Canada has a policy of not charging taxes on insurances when you buy it yourself. Now, although the person pays half of the premium and the employer pays the other half, the employer pays the other half on behalf of the Canada Pension Plan contributor. So really, the contributor pays 100% of it. Now, according to Canadian tax law, you can't tax something, a long-term disability policy, after they pay the premiums 100%. That's another reason. Now, I'm getting a bit sure. Last week I thought I was getting a bit dry from drinking, but I was coming down with something. I was a bit sick for 3 or 4 days. Now, the Granovsky Supreme Court of Canada case, 2000 Supreme Court of Canada 2000 issue, drawing the legal line somewhere. Now, although I made a note of this months and months ago, that was the issue I was going to talk about. That they said the government has to draw the line somewhere. Because a guy had become disabled. He had sporadic earnings, which are related to work. And when he applied for Canada Pension Plan Disability, he didn't meet the 4 out of 6 year minimum qualification period that I'm always talking about that I didn't meet. And yet I got Canada Pension Plan Disability, which is a huge liability for me. Now, so this guy got it. I didn't get it. He wanted it. He applied for it. The Supreme Court of Canada ruled that the government has to draw the line somewhere, and they drew the line at 4 to 6 years, and therefore he can't qualify. Now, it occurred to me recently, and I made a post about it, so I'll get it up here. The thing is that let's look at Buddy's situation. He couldn't work. He had no income, therefore. And he applied for the Canada Pension Plan Disability, would have gave him his contributions back, and then he could have lived on the money he got from his contributions that were paid into the government. Now, back in 1964, Minister Judy LaMarche spoke about help as of right, that instead of having to have needs-based payments for people who are disabled, that the Government of Canada would create a social insurance that would allow a person to retain their dignity. That instead of having to beg for welfare, they would get their Canada Pension Plan Disability when they become disabled. And yet, after the Granovsky case, where the Supreme Court of Canada ruled against him, I can't see any other choice but he would have to go to welfare. He couldn't work. They denied his Canada Pension Plan Disability. So what other option did the man have? Now that goes directly against the spirit and intent of the Canada Pension Plan Act as described by Minister LaMarche when she said you would get help as of right. Now, ironically, it also puts the tax burden, because welfare is funded by provincial taxes. So the Supreme Court of Canada punted the problem from the Canada Pension Plan having to pay the man, and he would have got his own contributions back. And then they said, no, you're not getting Canada Pension Plan Disability, which directly increased the taxes for whatever province the man lived in. Because they would have had to pay him welfare, which is funded by the province. And the irony, as I was saying, is that there was a thing called the Peterborough Project in Ontario in the 1990s. And they were looking at how to save money for the provincial welfare system. So they looked at that and they forced 25,000 people to apply for Canada Pension Plan Disability to get them off provincial welfare rolls. So I think what we have is a war, economic war, power war between the people who administer certain programs, like the Canada Pension Plan Disability. The Canada Pension Plan doesn't want to pay. They would rather that welfare pays. Welfare, the provincial system, they would rather have people on Canada Pension Plan Disability. Now, I agree with the minister from 1964. A person should get their money back. You pay into the Canada Pension Plan, you buy insurance, a social insurance. So if you become too disabled to work, then you should get your Canada Pension Plan Disability, and if that saves the province's money, so be it. That was the design of the program. Now the point, getting back to, because it's jogging my memory as I'm talking about it, the point about where to draw the line that I wrote in the notes for, to put the idea in my head what I could talk about. Who says the line is fair? They said it was 2 out of 3 years from 1966 until 1998. So that was 22 years that they said 2 out of 3 years was okay. Now you might say, what's the difference? Doesn't seem like much, 2 out of 3 versus 4 out of 6. Well, it doubles the vesting period. It also increases the time for you to apply successfully. Now, if you're thinking that this is some kind of conspiracy or collusion where the government and the insurances and the provinces are trying to screw people over, doubling the time to approve people would fall right into what I'm talking about. Because instead of only 1 year to make people apply, now they doubled it and made it 2 years. It could be a coincidence, but does it really help anyone but the insurances and the provinces? Now, I don't know, they should have had, and recently I was trying to figure this out, so I did a little bit of searching again. I haven't been doing searching so much as just talking about points I've already discovered in the past. But I found a report from 2007, I'm going to say, maybe, or 2004, 2005, and it might have been 2002, and it was talking about the 1998 changes. Now, I never knew that the provinces had been discussing the problems with the Canada Pension Plan for years before the 1998 changes. I was kind of wondering, did the provinces get consulted about the Canada Pension Plan disability changes in 1998? But one of the things I discovered, it's not nice. They talked about the advantages that women had. Now we have a Charter of Rights and Freedoms. Section 15.1 of the Charter of Rights and Freedoms says that gender, male and female, you're not supposed to discriminate against them. Now, they were saying that the women get an advantage for, say, the Canada Pension Plan disability because they live longer. Now, that's disgusting. My elected government in a democracy should not be comparing men to women and then trying to say that they get paid more over time, and that's bad, when they wrote a Charter of Rights and Freedoms based on the United Nations Charter of Rights and Freedoms, or whatever the hell they call it, and you're supposed to treat people fair. Now, first of all, the idea that you can compare how much you get over a lifetime to somebody else from one person to another thing is a bullshit, okay? Bullshit. For example, there was a senator's wife, but he was in his 80s or 90s, and he had a 20 or 30-year-old wife. And it was in the news talking about, oh my God, she's going to get $1 million after he died in a spousal pension. What they didn't say was it was over 50 years or something because of her young age. And the fact that they extrapolated how much she was going to get, I mean, you got to live on that pension. If it's only $20,000 a year for 50 years, it's $1 million. But you got to live on it. You're not going to get rich on it. See? Now, I actually saw a similar thing as I'm talking. Peter Stoffer mentioned something similar one time. He said someone could be said to be a millionaire if they were getting $20,000 a year for 50 years. So, you know, the fact that you had to live on it makes that a moot point, really. Now, I'm going to read off because I don't want to be here all night. You don't want to be here all night. I'll go through a longer post I was talking about, and I might add to it later. But recently I've been wondering about how the fuck, excuse me if you're getting offended by the odd curse word, but you know, I'm offended myself by the way the government treats disabled people. So I've been wondering, how did Canadian Forces Superannuation Act Section 15.2b, RCMP Superannuation Act Section 15.2b, and the Public Service Superannuation Act Section 11.2 came into being, and those are the bridging parts of these acts? I don't know. I'd like to see the legislative history, and I'm thinking about going to my Member of Parliament, Seamus O'Regan, and getting them to go to the Library of Parliament and get for me, for the society really, tell us how this law developed, and was it debated in Parliament? Because for them to put a law on the books that deprives people of their property, I would expect that to be debated in Parliament. The first thing they ought to ask themselves is, do we have the constitutional authority to affect people's property and civil rights, because pensions are property and civil rights under Section 9213. Anyway, under the Constitution Act, they divided the laws, the jurisdiction, the power of government between the federal government and the provinces, because we have a constitutional parliamentary democracy, and they assign certain things to each one, like defense is national, health is provincial, while work and labor, property and civil rights are provincial, exclusively. No wiggle room, really, although there is, because they have acts in the federal books that are federal. But I recently came across the reason why that's okay, even though I had deduced it myself, is that when they make a law that's towing the line to the provincial rules, that's okay, as long as you don't go trying to make up new rules that upsets the apple cart, because it's not your jurisdiction. So anyway, let me read this off as I was planning on doing. The Canadian Forces Public Service Superannuation Act and RCMP Superannuation Act Clawback Debate Preliminary Post, because I plan to do some more digging into this. I've often wondered how the federal government managed to steal the pensioners' property, so I started to review the action of Peter Stoffer to end it. He started in 2004. I'll lay out a few facts and then comment on the bullshit the government spouts. Number one, pensions are property. So I put in my quote of where I got that. Clarke versus Clarke, Supreme Court of Canada, 1990. So don't argue with me that it's not property, it's income or some shit. It's been to the Supreme Court. If you think it's income, go fuck yourself. You're wrong. 2, pensions are forced savings, plus they help recruitment and retention. Now my source for that was Roy, Federal Court of Appeal, 2003. Pensions are beneficial to the employer. Nolan, Supreme Court of Canada, 2009, including, because I mentioned the previous point about Roy, Federal Court, 2002 or 3, including recruitment and retention. Because, you see, companies and the government need workers, so pensions help people decide to join that employer. And after they join, they help people stay, because the longer you contribute to the pension, the higher pension you get. So that encourages people to stay with the single employer. Number 4, the Canadian Forces Superannuation Act et al., this something means including, are defined benefits or DB pensions which do not require a monetary contribution. Now that comes from IBM Supreme Court of Canada, 2013. Number 5, there might have never have been any debate in the House of Commons with respect to clawbacks for bridging, except for the pictures that I will add here from Peter Stoffer's efforts, because I admire the man for trying. Number 6, contributions are not taxes. Many people, especially employers, and probably Canada Revenue Agency, where I worked at one point, from 1996 to 2012, I was with CRA, and I was a payroll tax collector, which kind of brings this point home. Nobody ever explained to me that CPP and EI are contributions and not payroll taxes. I'm pretty sure that most everybody in the world thinks that these payments that are deducted from your check when you work are taxes. Well, they're not. I'll explain the difference briefly. A tax can be used by the government for whatever purpose the government deems fit. A contribution, on the other hand, can only be used for the express purpose it was collected from the individual. So the Canada Pension Plan contributions have to go to the Canada Pension Plan Fund. The employment insurance premiums, although that's a tricky one because the government put a law in there that they can use it for general revenue. They shouldn't have, but they did. So the government has used the EI money as a slush fund, but it's still supposed to be a contribution for the express purpose of getting insured to get employment insurance if you become unemployed. Now, point number 7. Pensions are deferred pay. That comes from the Clarke versus Clarke Supreme Court of Canada 1990 case. None of the taxpayer's business, except when the executive branch negotiates with unions, maybe, but even then the government can break the deal with no penalty. Now, what I'm referring to is back in the 1990s, the government was having a lot of financial difficulty, and the unions all had negotiated contracts in place, but the government said, nah, rip it up. We're going to put a wage freeze in from 1994 to 1996. So they put a wage freeze in there to save money for the taxpayer, even though they had negotiated increases in pay at the negotiating table with the unions. To me, that's the height of dirt. Heights of dirt. That should not happen. You sit down and negotiate with the union as the employer. You stick to your deal, because if you don't, we can't trust you. Tell me I'm wrong. But the government thinks they can do whatever they want. Okay. Number 8, pensions are not an indemnity for anything, including lost wages, salary, etc., as they are property, assets, and they represent a loan given to the employer by the pensioner. So, when you contribute to a pension, you're basically giving your employer a loan, and they agree to pay you back when you retire. Now, that's one of the reasons why bridging is wrong, because you have 2 loans in place, the Canada Pension Plan loan and the Canadian Forces RCMP and Public Service loan. And then they say, well, because you're getting this loan paid back to you, we're going to reduce the other money we're going to pay back to you. Son of a bitches. Okay, comments on the attached pictures. 14th of November 2005, Peter Stoffer introduced the bill, and that's it. Nothing for the next thing except he put it on the books. Right. Then he did the same thing, just put it on the books again on 10th of April 2006, on the 7th of February 2008, and then on 21st of November 2008, when it came up again, he mentions a fellow I spoke to before he died, John LaBelle. Now, John LaBelle was working pretty hard to get the bridging thing fixed before he died, obviously, 2 or 3 years ago, I believe. Now, the next one, though, on the 25th of March 2009, Peter Stoffer makes a case for an equitable end of the, what I call, despicable theft. Now, let me look at a picture of that one. I'll see if I can find it and read a little bit off, because all the previous pictures I put there was just, here's our bill. In one of them, he forgot to mention the disabled. He mentioned ending it at age 65, because that's what John LaBelle and them were mostly looking after. They were trying to get the end of it for healthy people at age 65. Now, in my humble or not so humble opinion, I think that they ought to be looking at, including the Royal Canadian Legion or anybody else that's trying to fix this, look at the disabled person first and fuck the healthy retiree until we fix the problem with the disabled people. That's my not so humble opinion. So Peter Stoffer on the 25th of March 2009. Mr. Speaker, my almost whatever. Okay, I'll go back to point number 1. 4 years ago, these gentlemen came to my office, Mr. John LaBelle, Mr. Robert Boutin, and Mr. Mel Pittman. These 3 men had served their country with pride, distinction, and honor. They came to me to talk about a problem they had for many years. They called it a clawback of their pensions at age 65 and a clawback of deductions for Canada Pension Plan disability. When a person is retired or released from the Canadian Forces or the RCMP and they collect Canada Pension Plan disability, that amount of money is deducted from their forced pension. That's true. But why? Now, the second footnote of point I made of this picture I put on there said this happened in 1965, 1966 with the invention of the Canada Pension Plan. No, it didn't. Seems like all these people, the politicians, the government, the executive branch, the legislative branch, they seem to have been hoodwinked, or they want to hoodwink us into thinking that this was what they designed. When Miss Judy LaMarche, on the 9th of November, 1964, was asked a question by a Conservative opposition member, a Mr. Chatterton, who said, what happens if a person who's in the public service becomes disabled? And they're going to get a disabled public service pension. Well, will they get the Canada Pension Plan disability too? And I guess they want to save money. Conservatives being conservative, I shouldn't say that. I'm not exactly liberal or NDP. I'm more conservative than anything. But you should draw the line at stealing people's money. See? You want to save money? Do it legally. Don't steal people's contributions to their pensions. She said, yes, of course. He will get them all. If he had 5 or 6 pensions, he will get all of them. Now, she was a lawyer. I think she knew pensions were property. And I think she answered the guy, I don't know what he was, and expected him to know that pensions were property. And to expect him to, like, why are you asking me this stupid question? You know, that's my take on it. So, the government came up with what's called a blended program, which means that the folks at the time were paying in the superannuation. When the CPP came along, the government indicated it did not want deduction to up the deductions. Oh my God, that's such bullshit. As well as federal and provincial public service, the government blended the package and said they will pay so much into the account of pension plan and whatever. Now, here's the problem with it. Canadian Forces pension, public service pension, the RCMP pensions are all defined benefit pensions. What you pay into it doesn't matter because you will get a certain amount based on a formula. It doesn't matter how much you contribute. See? So all of these people are talking outside, the other side of their mouth, is that the saying? They're lying, or they don't know they're lying. They're misrepresenting the facts. Because the fact is, these pensions are still property. These pensions have to be paid back to the person who it is owed to. And in fact, it is considered to be a crown debt. Okay? So that's a debt that's owed to the crown, or it could also be the reverse, a money that is owed from the crown to a person. So in either case, that is considered to be a crown debt. Well, when the government holds on your money in the Canada Pension Plan, or the Canadian Forces Pension, or the RCMP or Public Service Pension, when you retire, they owe you the debt I keep talking about. And that's a crown debt. And the crown owes you money. So the crown is not supposed to say, well, we don't owe as money to you as you thought we owed to you, because, we passed a law to say that, we're going to lessen your payment under the Canadian Forces and the Public Service and the RCMP Superannuation Act. Well, tell me this. If that's okay, why didn't the Canada Pension Plan Act say, if you get one of these federal public service pensions, we're going to reduce your Canada Pension Plan? Huh? Why didn't they do that? Well, you got to have a fall guy, see? So they want to make it look like the Canada Pension Plan is what's called the first payer. So anybody other than the first payer would get to take into account the first payer, and they'd be the second or the third payer. But they would save money because you get money from somewhere else. See? And that's not how things are supposed to work. Now, I'll tell you an example where that will be okay. Welfare. In the case of someone getting support from the government, I got no problem with them asking about how much money you're getting. And if you get money that's coming in and it saves the taxes that people pay, that's it. You're getting charity. Don't complain. But the Canada Pension Plan is not charity. The Canadian Forces Pension is not charity. Long-term disability insurance is not charity. All of these things are financial products that we bought and we should get. Now look for the other one first. Okay, there was a fellow that I tried to call when I came across this quote several years ago, back in 2015. An Alberta Member of Parliament, don't say where it is, but he was a parliamentary secretary back when he did this quote here that would have probably been the reason I called up his office, but he had lost the election. So I got the Liberal Member of Parliament's office. They kept the same number and the same office, evidently. So I'll read the whole thing off because he's so smarmy, it's disgusting. Now, this guy used to be in the Royal Canadian Air Force. So I don't know why he turned his back on Canadian Forces members. Mr. Laurie Hahn, Parliamentary Secretary to Minister of National Defence, Canadian CPC, what, Conservative Party of Canada, CPC, whatever. They're not even that anymore, I don't think. Are they? I don't follow politics that much. Madam Speaker, no one respects and values the members of the Canadian Forces and the RCP more than this government, and I appreciate that from both sides of this argument. The member knows full well that this requires a royal recommendation, so he's pointing out a technicality that the private member's bill can't succeed, he's saying, because a private member's bill won't cut it, that the government, the royal recommendation needs to do it. That's first of all. This is unfortunately largely for show. So he's calling down Peter Stoffer, saying that they're trying to make the Conservatives look bad. I do understand and appreciate the emotion behind it. Well, calling someone emotional means they're not logical. That's an insult. I will not bring up his voting record on veterans because that is shameful in itself. Now, that was a snarky comment too, wasn't it? Members contribute between 1/4 and 1/3 of their pensions to their pensions, and this bill, I'm inserting editorially the word, proposes to increase benefits beyond what members have actually paid for. The honourable member has alluded to costs, but he does not give a specific number. Does he have a specific number for the one-time cost and the annual increase, and who does he expect to pay for that? Taxpayers, members, or whom? Now see, unfortunately I've read a lot. I say unfortunately because it makes me aware of the bullshit this fucker is spouting. In 1973, for example, in the Supreme Court of Canada case called Gill versus CPP, I posted the picture in the comments here. They said, but the man, and they're talking about, okay, I'll read the whole thing instead of just the red box that I put there, because they said they were talking about Perry versus Cleaver, which is a case I often refer to, and they said Lord Pearson and Lord Morris Bath something dissented is sufficient to quote two short extracts. Lord Reed said at page 16, what then is the nature of a contributory pension? Is it in reality a form of insurance, or is it something quite different? Well, it's a form of insurance. The products of the sum paid into the pension fund are in fact delayed remuneration for current work. Now, see, when I say that you're getting paid money in a pension for past service, I mean, that's what the judge said in this 1973 case. I'm not quoting, I'm not making shit up myself. You're getting a pension, you're getting money earned in the past paid to you in the current time. That's the nature of a pension. That is why pensions are regarded as earned income. Yeah, they're earned in the past, not in the present. But the man does not get back, in the end, the accumulated funds paid into the fund on his behalf. This is a form of insurance. Like any other kind of insurance, what he gets back depends on how things turn out. He may never be off duty and may die before retiring age, leaving behind no dependents. Then he gets nothing back. Or he may, by getting a retirement or disablement pension, get much more back than he had paid in on his behalf. I can see no relevant difference between this and any other form of insurance. Now, I don't know what, I think he was a pilot for it, huh? But he became a politician later, so maybe he was a lawyer, but why didn't he know this legal fact? If he didn't know it, how come the Department of Justice lawyers didn't say to them, before they got on with their bullshit about you getting back more than you paid in, explain to him that that's just simply how insurance works. Some people will get back more than others, and that's the way the cookie crumbles. I mean, it's anything else is insane. They're trying to make it seem like we're doing something dishonest, trying to get more money than we should get. I think that's their main goal, is to make us feel guilty about asking, because they said, who do you expect to pay for the increase? Well, I've seen so many people talk about the taxpayer stake in the public service, the RCMP, and the Canadian Forces pension. Let me explain what the public interest, the public stake is in those pensions. Zero. None. Because pensions are delayed remuneration. that is money owed to you from the past, then the government just has to pay whatever the bill is to keep the pension fund afloat, because that's what a pension administrator does. The actuaries look at the number of people getting it and they extrapolate into the future how much money they're going to get. And then they try to figure out how much money they have to keep the money afloat, because you're supposed to invest it. You did this and that and the other thing. You look at what age people die. You look at, are they male and females? As much as I said before, they don't look at it in the actuarial sense. They do. And then they'd come up with, here's how much money you had to put into the fund. Now, as a matter of fact, the government never put a cent in until the year 2000. So anybody who served, like me, in the public service, I served from 1991 to 2012. So 1991 to 2000, there was 9 years in which the government said they were putting money into the pension when it wasn't putting the money in the pension. It was only representing a paper liability. Now, the reason I know that is I saw it in a report I found from the 1991 Auditor General. But in the year 2000, with Bill C-73, the government changed that. And they started to put actual money into the pension funds. And as I keep saying, the fact that they did it right in 2000 doesn't take away from the fact that they did it illegally right up until 2000. How come nobody has said, how come the government thought they could get away with that shit? I mean, I gotta admit, there's probably not much harm, except in the fact that they thought they could get away with it. They should look at the rules of the game for other pension funds, or you had to have money in the bank. We have to have money in the bank. That's called the rule of law. Now, I'm going to get to that Blake Richards fella. I don't think he's an MP anymore either. And basically, some retirees argue that this is a clawback. It is. And that they deny benefits that they have paid throughout their careers. It is. But that is simply not the case. Now, when a person makes a statement like that in Parliament for the Hansard, and I can find it later, they ought to be sure of their facts right first, okay? They shouldn't, put their foot in their mouth. Unless, of course, they're trying to deliberately mislead us, okay? I want to assure the House that retired RCMP members are, in fact, receiving the full pension benefits to which they are entitled based on the plan design and the contributions they have made. Bullshit. No money is being clawed back. Again, bullshit, because they take the fact that you're getting the Canada Pension Plan, oftentimes Canada Pension Plan Disability, and then they reduce the amount that you get in the other federal pension plan. You can say it's not a clawback, but you could probably call it an offset. You could probably call it a set-off. You could probably call it a reduction or a deduction or a tax even, because clawbacks are a form of tax. Statements that retired members paid full contribution to both the Canada Pension Plan and their employer-sponsored pension plan are factually incorrect. I might try to have look this fellow up and call and give him an earful and tell him to go fuck himself, because contributions don't matter. Again, like their whole argument about bridging is that you got lower premiums, so therefore you shouldn't expect to get a full pension. That's their argument. Again, if it was a defined contribution pension, they might have a point. But like that judge said in the Perry versus Clawback, you don't get back the sum of what you paid in. That would be a defined contribution pension. It would appear to me, again, I consider myself to be a subject matter expert, or a SME, it would appear that the government would like these pensions to be defined contribution pensions and not defined benefit pensions. And it would also appear that they're trying to ignore the benefits that the government gets in pensions, and only they're focusing on the negative part about the cost of the pension. But they're ignoring the fact that they get to save on, let me see if I put that there, under the Nolan case, or I might have put that. Anyway, they get to save on recruitment and retention, the company benefits, the government, the employer benefits, Instead of people leaving after a few years and going to find another employer, they stay there. They want to get a higher pension. Well, they've got training and experience now. They're a more valuable employee or public servant or Canadian Forces member. So the thing is that the employer benefits from that. The government saves on current costs of paying people, because if they didn't have these pensions, they would have to pay you more money and let you worry about the pension, your retirement yourself. Because before 1966, Canada brought in the Canada Pension Plan, while retirement was basically an individual responsibility. But the government imposed, and this is one of my thoughts, and I'll spit it out there even though I wasn't going to say anything about it, I think the government broke the law. They took away freedom of choice. Most people are probably happy with that, and they wouldn't care. Because how many people think about, say, the Canada Savings Bond and putting away a few dollars, $100 a month, and then at the end of the year getting a $1,200 Canada Savings Bond, and they had forgotten about that monthly payment, and then they get a chunk of money, and they're happy to get the chunk of money. Well, this forced savings plan, as the Roy Federal Court of Appeal 2003 case stated, by passing these acts like the Canada Pension Plan Act and the Canadian Forces Superannuation Act and stuff, they're forcing people to just put away money for their retirement. Now that impacts on your daily life right now. If you're serving in the military, or if you're a public servant, or if you're an RCMP member, you're going to have expenses. Every dollar that you put away for the future is a dollar you don't have right now. And this is one of the problems I have with the Canada Pension Plan, which has increased from 1.9% back in 1966. Now it's something like 5 or 6%. And then don't forget the employer pays 5 or 6%, so you're paying 12%. Now, I've read studies and reports over the years, and they say on average people don't want to put more than 5% into their future pension. But the government of Canada is putting 10% just into Canada Pension Plan. You know, when you put both halves together. Then, thinking back to what Laurie Hahn said, he was talking about, I have no doubt in my mind, that members contribute between 1/4 and 1/3 to their pensions. Now what he's talking about is that the government contribution is much higher than what the Canadian Forces member pays. In a 2007 report, Treasury Board Secretary put out about total compensation. They put a big table there about how much money over the past 10 or 20 years that the government has paid versus the Canadian Forces member. That's a red herring. It doesn't matter. You shouldn't have to pay anything into a pension fund to maintain the fund's viability, because that's the job of the fucking administrator. Last I looked, we don't have anybody on the Board of Trustees. So the government's trying to say that we're getting out more than what we paid in, when it doesn't matter what we paid in. It reminds me, and this is the upshot of it, is I think I'll shut up on this point. They're basically saying you're not worth what they pay you. Now, in the case of a person with a contract, the military don't have a union, but this is very insulting to someone like any union, who sits down and negotiates with the employer, and then the employer agrees to pay a certain amount. That's called the cost of doing business. It's not open to the employer at some later date to complain about the deal they signed. Okay? It's common sense, right? But do I have to quote the 1944 Supreme Court of Canada Richardson case? Because that's where I got the idea, and it's true. The Canadian Forces, RCMP, and the Public Service Superannuation Act contributions are nothing but a subsidy for the taxpayer. The government is getting a subsidy on its pension costs. And a lot of people, like the taxpayers, they don't get these pensions. They would think that's okay. But these are not public pensions. These are public law. Yes, I would agree. But they establish a direct analog to a registered pension plan, a private pension plan that any employer might negotiate with its employees. Now, when that happens in the private sector, I know of two ways that pensions are set up: under contract law or under trust law. So these are the two methods I know. Now, in the contract law, you'd probably have to spell everything out in writing in the contract, and both parties would have to agree and shit. Under trust law, you have to go by trust principles, which is the common law. And in the common law, you see, pensions are owned legally by the pension administrator, but they're owned equitably by the pensioner. See? Because they have an interest in getting their money back. Now, I said I'd shut up, but I can't help it. I got so many thoughts in my head, I can't believe this shit is happening. Okay? One of the things I was thinking about popped into my head today is, like in that Granovsky case, I can link it to that. He became disabled, he couldn't work. He had contributed to the Canada pension plan, and he wanted his money back. He put in an application. I look at that as a demand for his money back, his property back. Now, they put rules and regulations in place that said he was legally ineligible because he didn't meet the 4 out of 6 year rule. But under the criminal code, there is an offense for the government, or maybe anybody, to refuse to give somebody back their property when it's demanded. Now, an application isn't quite a demand, but pensions are property rights. So somehow they have people convinced that, like, oh, because they have a doctor's opinion or a nurse's opinion, that you don't qualify the definition of this, this, and this. They don't look at when the CPP denies someone, like in that guy's case, he never got his money back. He never got his property back. Now, of course, he will get it back at age 65 because they can't deny him totally. But disabled people die more quickly than other people. It's called mortality. I'm thinking about reviewing. I keep forgetting to do it, but I'll mention it here. Maybe I'll remember to do it. It'd be really easy to do. Here's what I'm planning on doing. I was wondering how many people die before they could get their pension. Just like that case from 1973, Gill versus Canada Pension Plan, or Canada, it's a railway company, CP Rail. I said CPP, but it's Gill versus CP Railway. Okay, so the thing is, I gotta get a drink and dry to here, but they said in that case that the Canada Pension Plan was a form of insurance. They said that it was a contract, and the premiums are consideration for the contract. Well, in 1993, the government set up a deal with 50 insurance companies to give them our Canada Pension Plan. I would view that as a violation of our contract. You know, they might have agreed to do it, but they didn't own it. You can't give away something that you don't own. Who came up with that bright idea? If you own something, feel free to give it away. But if you're merely the administrator and you're looking after the contribution for people, hard-working Canadians who pay into the Canada Pension Plan, well, you don't give away their money to insurance companies. You're not supposed to. That's against pension law. Under pension law, you cannot assign the right to the pension to somebody else. You can't sell your pension, even though it's your property. They want certainty. Like, imagine if you could, because usually you got the right to sell your own property. You could sell the right to your property to somebody else. They could give you a chunk of money, and then you could give them the rights to your property. Now, that should be legal according to normal. What you do with your own property is your own business. But it would make the pension administrator's job extremely difficult. So they agreed, the governments did, that you cannot assign the right to a pension to somebody else. Now that's normal pension law. Everybody who's dealing with pensions should know that. Then how come the government allowed the Canada Pension Plan Disability to get assigned to other people and have the money get sent directly from Canada Pension Plan directly to other people after they sign an irrevocable consent form? It's insane. Now, how come this disabled veteran who's here yabbering away at you is the one bringing this up? And a person, quote, like, saw one of my posts the last few days, and I don't look at comments very much anymore. I just post something and forget about it. But they said, the lady said, has anybody taken this to court yet? Not yet, I said. Now, the unspoken question there is, how come you haven't done it? Probably. I don't trust the system, unfortunately. The Granovsky case, they could have said, well, you know, this guy should get his pension because that was the intent of Parliament back in 1966. Instead of saying that the government has to draw a line somewhere, they could have said, well, we're not supposed to just try to save money for the Canada Pension Plan by denying a disabled person their property back, which would save the provinces money. So the government of Canada is a federation of provinces. So if they save money from the provinces, it's the same thing as saving money for Canada. And clawbacks, again, I wish I could shut up. Somebody needs to look at, are clawbacks good public policy? Now, people that work for the government, politicians and the executive branch, they'd say, of course. And then you'd say, why? It saves the government money. Well, I'm not so sure about that. If the person had more money because they didn't claw something back from something else, I'll use bridging because that's what I've been yabbering, talking about so much already. Well, you'd have more money per year. I have about $500 a month, $480. They deduct it from my public service pension because I got to count the pension by disability. So say $500 a month, $6,000 a year. Now I'd have $6,000 a year to spend. Now if I spent it in the market, because you're not going to save it when you're disabled, you get less money. So you're going to be forced to spend it to keep living. Now, the stores that you frequent, your money will provide jobs for those people that sell you goods. The people that work at that store will pay income taxes because they're serving you as you buy goods. You buy their goods. When you buy the goods, you pay taxes on it. So the government would actually get some of the money back directly. Even though they look at a clawback and they say we're saving money, they get some back anyway. Now, I think that the government is actually losing money overall. And I could say I could prove it, but I haven't done the work, but I know that during the COVID relief in the States, they talked about the stimulus package and they had scientific evidence that injecting the money from the taxpayers into the economy would be a net benefit. Now, using that as my proof, I can state, assuming those facts are correct, that clawbacks are bad public policy because they hurt Canadian society. They might seem to save money, but in the long run, in the bigger picture, they actually hurt the economy. They actually hurt the tax base. And then, I can't help it, okay? I just can't. You're screwing over disabled people. That should be the alarm bell. You take a Canadian Forces member or an RCMP member, because that was the subject of Peter Stoffer's bill. They become disabled in service. They lose the ability to contribute to their public service or the RCMP pension. They lose the ability to contribute to the Canada Pension Plan. They get forced to apply for the Canada Pension Plan by the Service Income Support Insurance Plan or the Great West Life Policy. That creates problems with the Canadian Forces and the RCMP pensions because if you get approved, you lose money in bridging. Then you lose the account of the pension plan off your long-term disability if you're getting it. You lose it off your Canadian Forces RCMP pension. You lose it off your Veterans Affairs Income Replacement Benefit. When they get cut, they're going to have to pay legal damages to make people whole, because you can't take $1,000 a month that's paid in Canada Pension Plan to Captain Retired Matt Edwards and then deduct $2,650 a month. Ever since 2015, that's what's been happening to me. I'd rather not get the $1,000 a month because I'd be up $1,650 a month. How can they not understand that? If this was the private sector, it wouldn't happen, in theory, because long-term disability insurance companies, they have an agreement that you won't lose more than 100%. So they might decide to split it 50-50. That's their agreement, but it violates the law. Contract law, privity of contract. If I sign a contract with Sun Life or Manulife, that's my business between each of those companies, and it's not the business of the other company. So for the insurance industry to decide that it's okay, it seems like it's helping people, to only take 50% each. Well, you're doing it illegally because of the privity of contract principle in contract law. Only the parties to the contract are the ones that are privy to the contract, and it only matters to them. I mean, this is what the government's missing for that 1993 and 50 companies thing. Anyway, listen, I'll be talking all night. If I don't watch it, thanks for watching. I'll see you next week.